On May 1st, 2026, the Connecticut legislature passed a comprehensive AI framework with direct HR-facing obligations. Senate Bill 5, the Connecticut Artificial Intelligence Responsibility and Transparency Act, which the governor has indicated he will sign, is due to become effective in stages beginning October 1st, 2026. The following are among the provisions most relevant to employers, most of which are effective October 1st, 2027. Whenever applicants and employees interact with automated systems, employers must disclose those systems using plain language. Employers must provide written notices before using an automated tool as a substantial factor in an employment decision. Notices must identify the use of the tool, its purpose, the nature of the decision involved, the categories and sources of personal data analyzed, and employer contact information. AI tool developers must provide sufficient information for employers to meet these notice and transparency duties wherever the tool is intended, i.e. advertised, marketed, sold, etc., to materially influence employment decisions. Parties may allocate notice duties by contract, but the allocation must be binding and explicit. Employers will not be able to claim AI as a defense to discrimination claims, although courts may consider anti-bias testing as a mitigating factor. Employers will have a 60-day cure period for violations occurring on or before December 31st, 2027. Employers filing WARN Act notices with the Connecticut Department of Labor must disclose whether layoffs are related to the employer's use of AI or any other technological change. And finally, the law does not provide a private right of action. The Connecticut Attorney General will enforce. Connecticut is not alone in regulating employers' use of AI. Colorado, Illinois, New York, Texas, California, Maryland, Washington, and Oregon all have laws in various stages aimed at policing AI and other automated tools in ways that may affect employers. For example, Colorado recently amended its AI Act, which is intended to be signed into law and will become effective January 1st, 2027. The law, which identifies employment decisions as consequential decisions, is aimed at automated decision-making technology, or ADMT, that processes personal data used to materially influence a consequential decision. Under the law, employers must provide targeted disclosure, which, like in Connecticut, developers are required to provide sufficient information to do. Employers must give clear notice before and after using ADMT to materially influence a consequential decision. Employers must provide opportunities for correction, and they must provide the right to request human review. Like Connecticut, there's no private right of action. And New York City's Local Law 144, which has been in effect since 2023, prohibits employers and employment agencies from using an automated employment decision tool, which is defined as an automated process, or AI, that is used to substantially assist or replace employment discretionary decision-making, unless certain conditions are met. 1, the tool must have been subject to a bias audit within 1 year of its use. 2, information about the bias audit must be publicly available. And 3, certain notices must have been provided to employees or job candidates. So, what does all of this mean for employers? It is critical to stay apprised of the changing legal landscape and identify any obligations you may have if you're using AI or other automated tools. Consider whether you need to improve your disclosures, provide notices, implement bias testing. Think about whether you need to update your contracts with vendors to facilitate compliance. For more detailed information on the various states' laws, please look out for a labor and employment client alert, which will be circulating soon. Also, check out our prior LaborSpeak, linked below, where we discuss using AI in hiring, and Kistler v. Eightfold AI Inc., a class action lawsuit filed in California, alleging that Eightfold's AI-powered hiring platform violates the Fair Credit Reporting Act. And finally, remember, if you need any help navigating the changing legal landscape, contact a member of our team.